We now head to Rivers State, where a political analyst, Mahmoud Jega, says Rivers State Chief Judge Justice Simeon Amadi is the main obstacle preventing the State Assembly from impeaching Governor Siminalayi Fubara. Speaking on television, Jega claimed lawmakers loyal to FCT Minister Nyesom Wike are setting traps for Fubara to justify his removal. The lawmakers, led by Martin Amaewhule, recently won a Supreme Court case restoring their legislative powers. On Thursday, they locked the governor out of the assembly, citing lack of notice for his budget presentation. Jega warned that the lawmakers are now targeting Justice Amadi, who they accuse of falsifying his age to clear the path for impeachment proceedings. To discuss this, we're joined by a lawyer and public affairs analyst, Towo Oserowoja. He joins us from the United Kingdom. Thank you so much for joining us, Towo.
You're welcome.
Please speak to us on the legal barriers that exist that could prevent the Rivers State House of Assembly from proceeding with Governor Fubara's impeachment.
Well, first of all, I don't really know where the legal barrier is going to be because the procedure must be followed as stipulated in the Constitution. And from all indication, I don't think there is any ground for impeachment as it is now, except to look at it politically, not legally. The Constitution states grounds upon which a governor can be impeached in Rivers State. And you could recall that immediately the Supreme Court judgment was issued or was delivered, in less than 24 hours, the State House of Assembly issued an ultimatum to the governor to submit or present the budget. And the second letter again has to do with sacking of his commissioners. And from the public domain, which I believe is also, we will say they are sketching facts, the governor has made several efforts to meet or to reach out to the current Rivers State House of Assembly, and is to no avail. And at the same time, again, you could see some constitutional breach because this is the first time in the history of Nigeria where a house can adjourn sine die. That word are basically used in the legal courts, not in the legislative house, which gives them constitutional required days they should sit in a year. So it's really disturbing. Therefore, the aspect of this chief judge, I think it's not an issue because if you look at it, anything that has to do with judicial officers in Nigeria, it has nothing to do with the DSS investigating. The first point of call is the NJC. So the House have not taken that step, but want to see the coercive or the method or the reason behind them going to the DSS rather than petitioning the chief judge to the NJC.
Okay, so but what could be the consequences if the lawmakers succeed in removing him? That's the chief judge.
Well, the lawmaker cannot remove the chief judge of the state. The lawmaker requires the lawmaker also requires the assent of the governor, and at the same time the recommendation of the of the NJC, which is the National Judicial Council. They need that requirement from them. So it's not just an open check for the State House of Assembly to just take over or sack or recommend. It has to. There are procedures for a chief judge to be removed. Even a judge of a state high court, there are procedures that should be followed. And the first point is a petition for a reasonable ground of misconduct against the chief judge that ought to be submitted to the NJC, which is the body that looks and disciplines judges. So that is the first point in court, and that point has not been done. And another thing again is based on the recommendation of the governor to the State House of Assembly, then it will be recommended to the NJC for the chief judge to be removed. So all these are just, how will I put it now? I think it is a more or less an amateur political gameplay, or should I say, is an attempt to retwist the provisions of the Constitution.
Okay, so in your personal opinion, Towo, are the actions of the lawmakers purely within their constitutional rights, or do they appear to be politically motivated by their allegiance to the minister, Nyesom Wike?
Well, I don't want to join the public opinion that they are basically loyal to Wike, because in every situation in time, every man has a price, or every man knows what he's looking for. Even Wike, as he's sitting there, is also prone to issues like this. Well, the first point, of course, is that for them to have adjourned, for them to issue a public demand for the budget to be passed, well, it's within their constitutional requirement. If you look at section 120 through section 129 of the Constitution. Then the other thing again is for them to have locked the governor out. You see that it's more or less of political light rather than discharging of their responsibility. Then the third aspect of it is what some of us are a bit concerned is for them to have adjourned the sitting sine die. And I think the wisdom of the Supreme Court now will come to play. If you look at the case they are relying on, there is something the Supreme Court rely on in giving some consequential order, which so many people are concerned about, but it's bound to happen, and which we call the doctrine of necessity. And I think it's at time the Fubara legal team should sit up and look at the provision of the Constitution, because for them to have adjourned sine die, they are stopping the running of governance in that state. And I think basically the governor legal team can activate, or the same time see means of activating section 11, subsection 4 and subsection 5 of the Constitution of the Federal Republic of Nigeria to see that the National Assembly take over the proceedings of the State House of Assembly for the purpose of smooth governance in the state, till when the State House of Assembly decide to come from their indefinite recess, because they cannot hold the state to ransom and they cannot stop the state from running in a constitutionally operated way and manner.
All right, now, how much influence does the judiciary have in a case like this? Can the chief judge legally refuse to cooperate with an impeachment process?
No, the chief judge cannot legally cooperate with it. You see, that is one of the things we need to see, the vulnerability of the executive and the vulnerability of even the State House of Assembly members. But let me look at it from this perspective. If the Constitution is followed properly, first of all, what would they do? There will be a motion on the ground questioning bringing grounds upon which the governor is seen to be of misconduct. And after the motion is being presented to the State House of Assembly, a request will be made to the chief judge to constitute a panel which will inquire into the allegation. And you know, the Constitution makes the executive a bit vulnerable, because what they consider as gross misconduct, what is considered as gross misconduct is not clearly spelled in the Constitution. So it's when those provisions are complied with, the chief judge has no reason not to constitute the panel. So his own is to constitute a panel, but procedures must be followed. And those procedures, I think the State House of Assembly have not done that. Then the other area which I think Fubara should look at, which is political, is that the members are also vulnerable. If the people are against their action, a recall is inevitable too. I think we should put all those things into play, for we to check the excesses of what is coming from the legislative arm and also the executive arm in Rivers State.
Okay. Well, thank you so much, Tawa, for your time and for speaking to us.
You're welcome.